still referring to these things as mechanics liens. They're not mechanics liens. We're not mechanics. We're contractors. We don't do automobile services. We're contractors. Well, for about 17 years now, the term has been amended, and the new phrase is construction liens. A little bit more descriptive about what we do. Well, and they're also called claims of lien. No longer mechanics liens, so I just want you to be aware of that. The claim of lien has to be recorded anytime, and when I say recorded, let's assume that the project is in Broward or Palm Beach or Dade County. Wherever the project is, I don't care where you are, it's where the project is. If the project is in X county, you need to record in X county, and the claim of lien has to be recorded anytime during the progress of the work or thereafter, but not later than 90 days after the final furnishing of labor, services, or material to the project. Later on, we're going to talk about how do we actually fix that last day of labor, services, or material, because I've caught contractors on this where they thought it was their last day and it's not. But right now, we're going to go to the next page, which is notice to owners. We use notice to owners, but we don't really understand what they are. Notice to owners are exactly what they sound like. Notice to owners is a document that says, hey, owner, you don't know who I am, or you may know who I am. You may have seen me, you may have talked to me, but I'm not in direct contract with you. You have no obligations to pay me, but I want you to know that if I don't get paid by whoever hired me, I'm going to be looking to you to pay me. And the way I'm going to be doing that is by putting a lien on your property. So you better make sure that whoever you're paying, before you pay them, pays me. In other words, before you pay that general contractor, you're going to want to make sure that I, as subcontractor, get paid, or I, as material supplier, get paid. Okay? So the way I explain this is that I think of it like this. You got the owner. Let's just use this scenario, the simple one. The owner, the general contractor, and the sub. The sub has no direct link to the owner. He has the sub would have to jump over the general contractor to get to the owner in order to have any claim. Why? The owner is only contracted with the general contractor. They have no obligation to you. So in order to create what's called statutory privity, in other words, the statute creates the link between the owner and the subcontractor, or a material supplier, whoever it is who's not in direct contract, let's again assume it's a subcontractor, is by serving that notice to owner. That notice to owner creates that bridge, creates that link. But unless you served that notice to owner within no later than 45 days after commencing, you're not going to create that link. You have no ability to get to that owner. So again, if you want to have lien rights, you better make sure that you do them correctly, otherwise you lose it. You snooze, you lose. Well, application. The basic definition, the basic application is that, or the general application, is that the notice owner must be furnished by lieners who are not in direct privity with the owner. Now, can those people who are in direct privity with the owner serve a notice to owner? Absolutely. Is there any legal significance to it? No. Is there a business reason to it? Maybe. Maybe it'll, you know, for instance, like I represent some contractors that are in direct contract with the owner. There's no legal requirement to serve a notice to owner. It does legally nothing. I don't attach it. It'll never see the light of day if I'm in court. The only reason for serving it would be to try to convince an owner who doesn't know what it is to pay, because it's almost like you're about to lien. And just also know something, there is no such document as a notice of intent to lien. I get this question. No such thing. In other states, yes, there is no such thing in Florida. You either lien or you don't. It's good that you may intend to, but it doesn't mean anything. Anyway, privity. There's so many definitions in the lien law, but the lien law does not define what privity means. So this is what the courts, the Florida Supreme Court, has defined as what privity means. I usually just think of it as people who are in contract. And I know when I took the construction exam that privity was asked about a lot, but this is how the Supreme Court defined what privity was. Privity exists when the owner knows a subcontractor is working on the job, and again, this is for purposes of notice to owner. Privity exists when the owner knows a subcontractor is working on the job and that owner has voluntarily assumed the contractual obligation to pay as a primary debtor for the work. In other words, owner tells subcontractor, don't worry, just keep working. I'll pay you. Is that enough? Maybe. I'd like to see it in writing. The question's going to be, did that owner assume the primary obligation to pay you, or is that owner really saying, if you don't get paid by whoever hired you, I'll pay you? The distinction would be, if the owner's just saying, look, if you don't get paid, I'll pay you, that's not enough to create lien rights. You may have a contractual claim against the owner saying, hey, you breached the contract, you told me you'd pay me, you jerk, you didn't pay me. Okay, I did the work. Okay, but that's not going to create lien rights. So get that notice to owner in there. Let me give you examples. Here are two cases. Owner giving instructions to a subcontractor, not enough. That was the Tompkin case, came out of the 4th District Court of Appeal, which is exactly where we are. They govern this Broward and Palm Beach counties. Owner visiting lieners' showrooms, selecting cabinets, contacting the lieners for delivery dates, contacting the liener for corrective work, still not enough. And that was a Middle District of bankruptcy case in the state of Florida. That's a federal case. So, walking a project, picking out paint colors, telling you where things may go, being intricately involved in the project, not enough. I just want you to understand that. They're not obligated to pay you just because they talk to you. Or excuse me, they're not obligated to have a lien enforced against them merely because they talk to you. They may be obligated to pay you if they agree to pay you, but that's going to be a breach of contract claim or some other kind of claim. Exceptions to the no privity. So in other words, let's assume that you have no direct contract with the owner. Do you still need to serve a notice to owner? Or excuse me, are you required? Maybe. Here are the exceptions. Even though you're not in direct contract with the owner, the following people do not need to serve a notice to owner. Individual laborers. The guy who works for the roofer, who's up there laying tiles, does not need to serve a notice to owner. That person has lien rights if that laborer, that individual person, is not paid. Now, labor pool companies, they need to serve notice to owners. So in other words, if Southeast goes over and picks up a bunch of laborers over at the labor pool, those laborers, if they don't get paid, have lien rights. The labor pool company does not unless they serve a notice to owner. Professionals, like what we talked about before, the architects, the engineers, the surveyors, the interior designers, they don't need to serve notice to owners. Subdivision improvements, again, there's an exception for them, do not need to serve notice to owners. The common identity theory, that's the next one. For example, the owner and general contractor are for all intents and purposes the same entity. I've only had to raise this up maybe 3 or 4 times. This is raised when you screw up. You didn't serve the notice to owner. Well, next thing that I'm doing is looking, did you have to serve a notice to owner? Do you fall within one of these exceptions? In other words, are you in direct contract with them? No, you're not in direct contract. Damn, that's the easiest one. Are you a laborer? No, you're not a laborer. Are you a professional? No, you're not a professional. Well, maybe we can get you into this. Maybe there's a common identity theory. And that is does the owner and the general contractor, are they, for all intents and purposes, the same person? Sometimes you find out that the general contractor and the owner are one and the same. I mean, they're the same people running the company. It would be no purpose. Obviously, the general contractor that hired you is the sole shareholder